So the question that you may have is, are there alternatives to litigation? And so when you say litigation, what you're actually talking about roughly is a form of dispute resolution using our justice systems, meaning the filing of a complaint and going through a litigation process where a judge or a jury makes a determination on one side or the other. But there are a number of ways that you can resolve your dispute without needing to go down that path, which can sometimes be an expensive and time-intensive process. So if you've tried negotiations, meaning you've tried to resolve your dispute directly, you've put your ego aside, you've confronted the challenge directly, you've attempted to shape their thinking, to accept your side of it, you've made a proposal to get to resolution on whatever the issue is, and you've been unsuccessful, there's two mechanisms that are available to you that short of a lawsuit, that can try to get you to resolution. The first is mediation, and the second is arbitration. So mediation generally refers to a non-binding process. What that means is that whatever the result of it is, it has no impact, it's not enforceable against one party or the other. But the benefit of mediation is it's a very informal process. It allows you to have a referee call balls and strikes, try to get resolution, say, hey, you're wrong here, you're right here, you're wrong here, you're right there, and try to get the parties to come to an agreement to settle their dispute short of having it get to litigation. What's great about mediation is it's relatively inexpensive. You can find retired judges, so the same kind of people who are going to be making decisions inside your case, to be the mediator, to be the referee for your dispute. And virtually every state has something called a mediation privilege, which means that anything that's discussed at mediation, unless someone makes a threat of crime or violence or something along those lines, anything that's discussed in mediation is completely confidential and cannot be discussed, period, end of story, and the courts are very strict in their enforcement of that. The other process, right, so mediation, non-binding, informal, inexpensive, referee call balls and strikes, is the arbitration process, right? So mediation, arbitration. The arbitration process is more of like litigation light. So what do I mean by that? You generally have some kind of professional, whether it's a retired judge or an attorney in the area, who becomes the sole decision maker of the case. What is beneficial about arbitration, and I tend not to like arbitration, but what's beneficial about arbitration is, generally speaking, it moves faster than litigation. It's supposed to be less expensive, but what the trade-off to that is it's a much more curtailed, shortened process. There's limitations that you would, or rights that you would otherwise have in the legal system, right, in the justice court or in a court of law, that you don't get in arbitration. But the arbitrator can do a much more quicker job, more expedient, is informal, and the decision that they render has the force of law, unless there's a couple of exceptions why that's not the case, like if there's bias or something along those lines, or wrongdoing or fraud. But their decision has force of law, meaning it's binding. So what ultimately happens is, at the end of the arbitration process, the arbitrator hears everybody. It could take weeks, it could take months, it could take over a year. The arbitrator then renders a decision that's called an award, and then the award can be taken to a court to be converted into a judgment, and then a judgment is as enforceable as if a judge or a jury rendered the opinion. So short of having to file litigation, you have direct negotiation, which is preferable. If you can't get that to work, you have mediation, which is a non-binding process. And if that doesn't work, or you're not looking to do that, you have the arbitration process, which is a binding process that has all the force of law. It's more informal, should be less expensive, though that's not guaranteed, and could get you a result quicker and more efficiently, potentially, than a legal action. And then you always have the filing of a complaint and seeking justice from our courts of law. So those are the four processes generally. If you have any questions about any of this, my name is Michael Smikin. I'm here from Callagy Law. We're here to answer this or any other question that you have. Thanks.